We have with us today retired Justice Gautam Patel.
Thank you so much for having me.
Your transition from the bar to the bench, was it something that was always on your head?
The law was never in my head. I stumbled into it. Just fluked my way into law. I mean, really, it wasn't a plan at all. And judgeship was never a plan.
Right. What were some of the most difficult decisions that you had to make as a judge?
You know, the difficult ones were always ones that involved individuals or families, because you just didn't know that if you got it wrong, how much devastation was going to be visited.
Do you have any advice for young lawyers?
Remember that there is one asset that you have to build and then most jealously and zealously guard, and that is your reputation. You can have all the fancy cars in the world, but a lost reputation in a court of law is a total and utter disaster.
Hello, and welcome to GLC Law and Lore, a podcast where we invite legal luminaries from the prestigious Government Law College and shine a light on their journeys while getting to know more about them as people beyond the bands and gowns. We have with us today retired Justice Gautam Patel. He has had a profound career and has made significant impact in the fields of commercial, corporate, and environmental law. His career is not only limited to being an eminent counsel or a judge at the Bombay High Court, but he is also a lecturer, a prolific writer for leading newspapers, and is a respected voice in the legal discourse. What many people don't know about him that he is also a passionate photographer, an avid cooking enthusiast, and has deep love for animals.
Also true.
Team GLC Law and Lore extends a warm welcome.
Thank you so much for having me.
Starting with the first segment of our episode, sir, we would like to take you a trip down the memory lane to A Road, to your alma mater, Government Law College. Could you share some experiences from your time at GLC? How has it helped in shaping your career? And if you could share some fond memories that you had at
Oh yeah, many memories there from TLC. It wasn't as rigid or structured as it is today. It was a lot more, I won't say liberal, but a lot more relaxed. Some of the teachers were really outstanding. I remember Professor Pitawala, Professor Daruwala. They were just really outstanding lecturers that we had guide through. And we were given a lot of freedom to engage in the other activities. So the moot court thing was a major one at that time. It was really the one that was most structured. Today, you've got many more activities between debates and essays and your medars and so on, which are more structured. We didn't have all of that at that time. So moot courts were really our go-to thing back in the day. And then we had a series of these moot courts, both between colleges and National Day and then the international moots and within the college also. And it was a fun bunch of people. So we did all kinds of fun things. My first exposure to GLC was actually at a moot court. I had no idea what that GLC even existed. And Shamdevan dragged me off there saying, let's go and see this. So we went off and saw this. And all these great stalwarts, Shavak Swaridhar and Soli Cooper and Tushar Cooper were busy arguing. And I said, well, that's very interesting. I'd like to do that. So that was actually the introduction to GLC in the hall, which looked nothing like it does today, by the way. So it just was this one vast cave-like space. Yeah, it didn't have all this kind of formal seating. The furniture was movable. It wasn't air-conditioned. It was really hot. But it was fun. So anyway, those were great days.
And could you shed some light on how it helped in shaping your career?
Well, one of the things I found was that GLC had this fantastic library. And the library was really open access in one sense, because you could spend hours there reading and going through materials and stuff like that. So that was the first introduction to Basu and Sevai and really difficult concepts like this. So learning experience was terrific. But I was also lucky in one sense that I was already working with a solicitor at that time. So practical things kept happening at work. And then the library was a useful resource to be able to research that, because not everybody had extensive libraries. And of course, there didn't exist online databases back in the day. So this was actually a very useful learning experience. went off favor.
Right, sir. So moving forward, we all know that you were a junior in the chambers of senior advocate Janak Dwarkadas, and now many of the former interns who have in the past interned under your judicial chambers speak highly about their time under you. Ho- What we would like to know is how important is the role of mentorship in this field, and what practices have you personally incorporated for mentoring your juniors and interns?
Interesting question. Mentorship in law at any level and in any environment, to my mind, is absolutely critical. It's not only a question of book learning and what you get from some text or from some judgment, but how you apply it, and more importantly, how you approach the profession, the ethical parts of it, the responsibilities, how you conduct yourself in court, and so on. And Janak was back in the day not a senior, so that was a stroke of luck because he had a huge amount of drafting. So even in the drafting skills, how to marshal the facts and the evidence and how to get that flow in was a critical learning lesson from him. And about the practice of law, and I mean that in the broadest possible sense, I don't know if there could have been a better teacher than Janak, and he is one of those who taught without teaching.
Right.
He led by example, and you learned very quickly that he was just setting a standard, and he left it to you. And basically, you really understood how this man was functioning, thinking, what his priorities were, how dedicated he was to the profession, what complete professionalism actually means. And that was a huge learning experience. One of the things that Janak did, which I thought was invaluable, and I was lucky to have it at every stage, even in the office where I was working prior to that, was being pushed to doing two things. One is figuring it out for yourself, number one. And two, knowing that you had to have the courage and the wit to be able to defend your position. You may disagree with a senior. And Janak would often say this. He says, look, I may be wrong. Look it up. You may have a different point of view.
Right.
But if I question it, you'd better be prepared to defend your position, which was an important thing. That is something that I tried to bring forward when I was a judge and had judicial interns. One of the cardinal rules was do not ask me what this means, or do not ask me what the answer is. I don't know. Look it up. That's why I'm
Right.
here. My job was really to teach them how to teach themselves and then give them the opportunities to challenge themselves, push forward. I think that stood most of them in very good stead.
Right.
And then, of course, the difficult part of it in the judicial internships, because they all somehow thought that dictating judgments was easy. And I had to keep telling them that, look, if we make it look easy, me and my colleagues, it's because we worked very hard to make it look easy. Why don't you try it?
Hmm.
And they'd always be staring at this blank screen for 3 or 4 days, not knowing where to start. I said, that's the whole point. You have to know how to get this done. Plus, I think the other factor that was a huge learning from Janak is how to control time sensitivity in matters. I mean, things have to be delivered on time. You'd better be prepared on time.
Right.
And better get there on time, because that's not going to wait for you. You can't go into court unprepared and say, I don't know, I haven't prepared. That's not
Right, sir.
so that was a learning.
So, as a student, I have personally read various judgments passed by you, and
You need to improve your reading list.
and your command over language and the distinctive style of writing is something that has always stood out. Is it something that comes naturally to you, or was it something that you consciously worked on?
It's an affliction or an addiction to words, to language.
Right.
In there since childhood. My mother still says that her enduring memory of me was even while walking up and down the house with my nose in a book. So it was always words, language, syntax, what you can do, the pictures you can paint with words. So that was a mixed bag because it's a fascination, as I said, addiction, affliction, but it's also torture.
Right, sir.
You try and get it right, you try and get it better, and it's increasingly difficult. So it's very tough.
So, for any young student or any person who wants to improve their skills, what is that skill set that one needs to develop to
You have to read.
mastery?
You have to read everything. And I mean everything. I mean, you read outside the law as widely as you can. Look, if you look around you at the greats in the legal profession and those within, let's take those within living memory and not go much further back, though there are some astounding examples from back in the day. Every one of the greats today, whether you're talking about Ashok Desai or Anil Diwan or Soli Sorabji or Fali Nariman, Iqbal Chagla, Janak, all of them
Right.
have reading habits outside the law.
Okay.
They read poetry, they read classical literature, they read modern literature, they read fiction. They not only read the law, they don't only read judgments, they read outside the law. That's your introduction to the power of language and what words can do and how to use it precisely
Right.
and concisely. And it comes from there. So my advice is read like a lunatic. Everything from the back of a box of cornflakes onwards, but don't stop reading.
Right, sir.
And if people say, I don't have the time to read, then you're doing something wrong.
I think that is an advice to stick by.
You're doing something wrong.
Moving on to the next phase of your life, your transition from the bar to the bench. Was it something that was always on your head when you got into this?
The law was never in my head. I stumbled into it. I wanted to do all kinds of other things.
So what? How did you end up getting?
I told you, I just fluked my way into law. I mean, really, it wasn't a plan at all. And judgeship was never a plan.
Right.
And I think it's a mistake for anyone to say, I plan to be a judge, because you're heading for disappointment.
Right.
You may not ever be a judge. And my advice to somebody who wants to be a judge is keep your mouth shut about it. Because the more you go around saying, I want to be a judge, make me a judge, the less likely people are to do it.
Right.
You can't hanker for it. There's a difference between wanting it or gagging for it and being willing to do it. And I wasn't really locked into wanting to do it ever. So, in fact, when I was asked, I had some of my conditions which were out of the norm. One was that for personal family reasons, I wasn't willing to move to another high court or another city. So I said, take it on those terms. So leave it. Others, I'm happy to go back to doing what I'm doing. So I told the Chief Justice at that time, Chief Justice Mocha, that look, I'm willing to do it and I'll give it my best shot and I'll see it through. But if it doesn't work on these terms, it doesn't work, it doesn't matter. So that was the transition. It was on those terms entirely.
So, sir, when judgeship was offered to you, what was your first
Panic. Complete and total panic. There's no other word for it. So first of all, your heart sinks a bit because this is like being hit by Thor thunderbolt. And then you have to get back, talk to family, talk to wife, talk to parents, and so on and so forth. So my parents had one overriding condition, which is that I would not move out of the house into official quarters. I said, that's all right, that's trivial. It was a bigger call for my wife, Malu, because it really meant that there were things that we were used to doing which we would have to now do and think differently. Because that was but she said, okay, fine. For her, it was really a question of making space in our lives so that I could get on with the work as a judge. So, but it's fine.
In your career during your judgeship, what were some of the most difficult decisions that you had to make as a judge, and how did you particularly deal with situations where both the sides had a compelling case?
You know, the difficult ones were always ones that did not involve corporates or or commercial entities. They were always ones that involved individuals or families. And you really had to work your way carefully through this because you just didn't know uh, that if you got it wrong, how much devastation was going to be visited
Right.
on the side that you held against. And there's a interesting anecdote which I should share with you. I was from very early days when I had interns, encouraging them to draft the judgment.
Hmm.
It's the only way you learn.
Yes.
Uh, not many judges do it, and I know that it's controversial, and there are people who say, how can you do it? But it's common elsewhere, and I saw no harm in it, provided it wasn't going out unless I saw every line of it, which was the discipline that was required. So I never sent out anything. And the challenge to them was to get this done. So I had these two young ladies who were interning at that time. It was a testamentary matter. When all three of us heard this same fact, same law, same evidence, and said, do it.
Right.
And a week went by, and a second week went by, and I wasn't seeing anything. So I said, where is this? Give us another week. I said, okay. Give him another week. I said, what's up? So there's a problem. I said, what's happened? Said, we can't agree. I said, fabulous. I said, that's the beauty and that's the power of the law. I said, are you seriously saying that you've taken different views on the same facts and law evidence? So they said, not just different views, diametrically opposite views. So I said, okay, one wanted to allow it, one wanted to dismiss it. I said, very good. Give me both.
Okay.
I got two absolutely top class drafts. I mean, they were really, really top end.
Hmm.
They required some minor cleaning up just to get them into formal legal shape. And I read one, I said, this is very good. Then I read the other and I said, but this is also very good.
Okay.
And it took me another 6 weeks to decide between the two of them which one I was doing and which view I was following. I didn't use either of them. I rewrote the whole thing. I did the whole thing myself. But I was so pleased to have these two divergent opinions. And that's really the power of the law. But the question there that both were addressing differently is, where does justice lie for the individuals involved?
Right.
So these are difficult cases, and they are difficult cases when you have the individuals there. So it's always a tough one. The big ticket corporate law interpretation is generally not difficult.
Right.
So,
So, given the immense pressure to deliver swift and efficient judgments, given the backlog of cases at the Bombay High Court that adds up daily, is there also an added pressure on deciding cases which affects the sentiments of lakhs of people? For example, the Sayadna matter, which you decided.
there's no pressure. You can't be pressured by things like this. These are, look, this idea that there is pendency cannot be a pressure point because there's a physical limit to how much you can do in a day. Secondly, nobody has told any judge that it's part of his oath of office or her oath of office to clear out the arrears
Right.
in her or his tenure. You can do only so much. There are some judges who do it very fast. Some judges take much more time. Justice Oak, for example, was blindingly fast. I mean, you just get right to it really, really fast. Back in the day, Justice D.K. Deshmukh was very fast. He would get to the heart of a problem in no time at all, unerringly. There are other judges who took longer. This happens all the time. Sometimes I'd take longer than a companion judge. Sometimes I'd do it faster. It doesn't matter. The pressure can't be that. The issues sometimes are bigger. In fact, Sedna was one of those which was least pressured because we knew we were taking evidence and it was going to take time. The only thing is how we conducted it and made sure that there weren't expressions used in court or in the proceedings which were likely to hurt. That was the only thing. There are other issues, political issues, reservations issues, for example, that have wide implications. That Dhangad thing that happened. And one of the things that you have to remember there is that if there is a public concern, you should be open about the whole process. So don't stop anybody from coming into court or joining online.
Right.
And that's why in the Dhangad matter, it was a long judgment, but I said it's too important. And I dictated it in open court so that, people saw that this was actually being done live in court.
Right.
So it was a 5-hour dictation, but it was a dictation done in court. That was the only way to do it. So it was running, tempers were running very high in that matter.
So, moving forward, people often remark, rightly or wrongly, that judges are supposed to act a certain way. What, in your view, is the ideal temperament for a judge? And how does one balance firmness with fairness?
Okay, this is an interesting question. Uh, the theory, at least on the ideal temperament, is that you need to be constantly uh, patient, low key, moderate, and so on and so forth. Now, this is not always possible. Uh, I'm not laying any claim myself to having been possessed of the so-called ideal temperament. There were times when I did lose my temper. I was also known for being very short and quite aggressive, as I said. That's less than ideal. Uh, there are many other judges, colleagues, I'm not going to name them, who I think are far better and are actually quite excellent in that field. Uh, but there is a lot of pressure in that direction. Uh, you mustn't forget that these statements about the ideal temperament of a judge is done at a time when there were fewer judges and there were a handful of cases for each judge, and the judges didn't have the kind of work pressure that they do today. I dare say that if you put one of these critiques or one of the critics of a judge, typically the kind of person who takes a video clip of a live telecast or illicitly records part of a hybrid online session and points out to the judge and says, see, look how this judge is reacting, look how hostile he's being. It's completely out of context. He has not understood what that judge is going through. Judges are human beings. They have the same feelings as other human beings. You can't expect them to be superhuman. One of these persons who criticizes judges for lacking the adequate judicial demeanor should actually be put to the test.
Right.
Send them 150 cases to read overnight. Tell them sit for 5 hours with that list of 150. Decide 150 or pass an order. Correct 150 orders that evening and read 150 for the next day and tell me you're not going to crack under some pressure.
Right.
At least once in the course of that 5-hour day. Now, it may be because, and of course, in all of this, no lawyer is ever to blame.
Yes.
So even if that lawyer is arguing the unarguable, is himself being hostile and is raising the voice, the judge is supposed to take all this. Now, this is not possible.
Obviously.
This is not possible. And one of the things that's coming in the way of maintaining this ideal or idealized temperament is also this absurd obsession that we've got with live telecasts
Right.
of court proceedings. I've said this before in a judgment and I'm saying it again now and I'm saying it openly. I'm wholly opposed to telecasts. I'm fully in favor of hybrid online hearings. I have seen no advantage to live telecasts. I disagree entirely that this is an aspect of access to justice. It is not.
Right.
It is equating justice with entertainment. All you need is now one more OTT channel seeing them, which is not what you really want.
Right.
And it is affecting the integrity of the decision-making process. Things are being taken out of context. Justice Gavai has quite rightly commented on this just a few days ago saying we need guidelines. I'm saying that forget the guidelines. You need to burn down the house. Stop live telecasts. Of course, if anybody is really interested in a particular case, even if he's not a litigant, he or she should have to make a little more effort than switching on a TV set or a computer.
Right.
Get to court. We have an open court system. Get a pass. Sit there. Take your notes. Behave yourself as you're required to behave in court. The problem with this YouTube live telecast is that the viewer is anonymous. You have no idea who's doing this. And the pressure on the judges is incredible.
Right.
Because you're live before an unknown audience. Lawyers typically, not all of them, some, will be given to grandstanding for the same reason, because they've got a ready-made audience.
Right.
And many courts, all of us have had this experience, rely on lawyers for their fairness. We rely on them to say, look, my petition raises 5 points. I don't think there is substance in points 4 and 5. I want to press points 1, 2, and 3. Now, the moment they say this, the public would see, what a terrible lawyer. He's given up points 4 and 5.
Yeah.
No context.
Yes.
Or if he says, this point is the law is against me, they'll never be able to make a fair statement anymore. What happens to the integrity of the process? What happens to the manner in which the judge is then to conduct the case? What happens to the demeanor of the judge, which is being plucked out of context? That one moment when the judge got shirty, got upset with a lawyer, is held up as an example to pillory the judge. But the 5.5 hours that the judge was kind, gentle, encouraging a junior,
Yes.
because it doesn't have any appeal, is not reflected at all. What's the advantage to this?
Right.
So you have to understand that this demeanor question is a bit of a mixed bag, and lawyers, like judges, and the practice of law requires you to develop a very thick skin. You have to have the hide of a rhinoceros and be able to absorb all of this.
Right.
The rough with the smooth. The only thing that I would say, which I have done, is that if the judge knows he's wrong and has been disproportionate in his or her response, and an apology is due, it should be done in open court.
Right.
There's no point having an altercation in court and then having reparations in chambers. If it happened in the open, it must be repaired in the open. That's the only other view I've got on this.
So moving on to the last question of this segment, I want to know if there was an opinion or a view that you had as a counsel, which later on changed after becoming a judge.
Oh, yes. Well, you espoused a cause. Well, I can give you straightforward examples. This whole thing on the Maharashtra Private Forests Act, which
Right.
led to the Godrej and Boyce judgment of the Supreme Court. I was on the other side of it, but which was canvassing for the protection of the forests and so on and so forth. But once you're a judge, you will take a long step back from that position. You're not going to use your position as a judge to reiterate that which you argued as a lawyer.
Right.
You are going to apply the law laid down by the Supreme Court. That's what the law requires you to do, and that's what you have to do. That's what the Constitution mandates you to do. In fact, it was very peculiar. I found that the state government was trying to advocate the same position that we had taken after the Supreme Court judgment, and I said, that's not on. The Supreme Court judgment will bind you.
Right.
It may be against everything that I argued. It may be against what you are saying now, but it's the law and it will bind you. You have to take that position. That's the discipline that has to be maintained. Absolutely.
Right, sir. Thank you so much. This brings us to the end of our first segment. So moving on to the second segment of our episode, we shall be discussing some contemporary legal issues and we'd like to know your take on them. Starting with the first one, media trials have increasingly influenced public opinion, and most of the time, even before the courts have had a chance to adjudicate upon them. For example, the Kunal Kamra case encouraged a significant public discussion Do you believe that this affects the fairness of trial and the impartiality of judiciary, or should there be stricter legal safeguards to prevent media outreach?
I don't think it affects the judiciary at all. It certainly didn't affect me. I don't think it affected my colleague either. It makes no difference. The press has a right and people have a right to discuss issues that are topical.
Right.
You can't stop that happening. And the work of judges is to make sure that none of that interferes with the decision-making process. The media trial pronouncement of guilt or innocence is much more complicated in criminal matters.
Right.
Recently, there's been a lot of controversy about 498A, for example. There are these questions about suicide, these attribution of guilt, the inability even of people whom I would expect to be more seasoned and more experienced to distinguish between what is bail and acquittal. Somebody gets bail and, oh God, he's been let off free, not understanding that it's not an acquittal.
Right.
These are more serious issues, and they reflect, I think, a societal impatience with the slowness and the slow pace of the judicial process. People want this done instantly. And part of this mania or fascination or obsession with instant justice
Right.
is also driven by cinema. And I've said this before, that you always have this super cop, whether you call him Singham or Suryavanshi or whatever it is, who's dishing out justice there and then and on the spot.
Right.
He's subverting a legal process. And there's a reason why the legal process is slow. See, there's a bunch of completely asinine comments flying around about law and how slow it is, mostly put out by ill-informed people in the medical profession. You've seen that WhatsApp chain.
Yes.
You have to understand a couple of things about how the law functions. We are probably the only profession, unlike architects, engineers, chartered accountants, doctors, who are constantly engaging in a public forum,
Right.
in litigation. I know that there is a non-lit work that's happening privately in chambers, but no doctor is performing surgery in an open-air theater.
Yes.
His operation theater is a closed event.
Hmm.
There's no question of letting outsiders come in and watch just because they're interested. There's no question of people waiting around for their next surgery. It doesn't happen.
Right.
They also don't have to do the one thing that we have to do, which is to decide between two rival cases. That's okay. You go to a professional, you tell him your problem, whether it's a tax problem or a medical problem or you want a building built, and he's addressing that problem.
Right.
Here we've got two counter narratives, one on either side, and the judge is going to have to decide between those two which is the likelier of the two. It's never an easy business. And for everybody who says, why can't they decide immediately? I would like the person who is saying this to be the defendant in one case and would like him to be told, we're deciding instantly without hearing you.
Right.
He's undoubtedly going to get up and say, no, don't be in a hurry. Give me a chance. Give me a 4-week adjournment so that I can explain myself. What happened to that whole saga about decide it instantly? Went flying out of the window. This is just ill-informed. But the right to discuss a topical issue
Right.
has to be preserved to the people and to the press. That's perfectly all right. The impatience with the judicial system is something that we're going to have to work against.
Right.
And partly it's also because we are adding to it. I think we need to improve our systems.
In particularly what direction would you want?
I think some of our systems are now really antiquated. They are inconsistent. They are contradictory. What applies in Madras doesn't apply in Delhi, doesn't apply in Bombay. Your websites are inconsistent.
Right.
There's no reason for this. There's a lot of inefficiency within the system itself. This needs to be ironed out as going forward. Once that is done, the decision-making process should be made as smooth as possible without these wrinkles in the fabric.
Right, sir. Moving on to our second question. The collegium system remains a debated topic in India. Is there a scope for reform in judicial appointments, or does the existing system, with all its flaws, still works the best?
I don't think it works the best at all. I think it's a terribly flawed system. It's apt to lead to inconsistencies. And unfortunately, what's happening is the quality of the decision making. I'm not on the quality of the judges appointed.
Right.
The quality of the decision making varies a lot depending on the composition of that committee at any level, High Court or the Supreme Court. There isn't a sufficient plurality of voices. There isn't a sufficient transparency in the process. Some of the results are wayward. We've seen this recently, and we've had enough examples of people as High Court judges saying and doing things. And the question is not why he said it, but why she or he was appointed in the first place.
Right.
This is a huge question mark. Some of this we see even reflected in judgments of the Supreme Court in appeal from High Courts, and some of this we see in High Court judgments when we're dealing with judges. See, the choice of a judge is a very difficult business.
Right.
It's a best judgment assessment. It's a bit of a stab in the dark. You're taking a call on it. You wait and you estimate that this is going to work. Sometimes it works as planned. Sometimes it works better than planned. Sometimes it goes haywire. But the problem is that you can't have a situation where it goes horribly and egregiously wrong. And there has to be some sort of a system that puts this imbalance. I don't know what that system is. This present thinking that the government should have no voice or no significant voice in the selection of judges is unique to India. It is born out of this experience of the past during the emergency and supersession of judges and so on and so forth. The time is gone. We have to move on with the times. We can't be harking back to that period now. That's not on. It's the only country in the world that does this.
Okay.
No country in the world does this, where the judges appoint themselves.
Oh, okay. Now, sir, moving on to a lighter note and switching some gears, we would like to move to the rapid fire round.
I hate those.
The idea is to just simply say the first thing that comes out of your head.
You really don't want my answers. So,
Are you ready?
I'm never ready for this, but I don't have a choice since I'm drinking your coffee, which is quite good, by the way.
Thank you, sir. What is your go-to stress buster after a long day of work?
Music. Oh, music and books, both.
Any particular favorite kind of music that you love?
Jazz.
Okay, sir. What do you like, dislike, and tolerate about being a judge?
What did I like, dislike, and
That you tolerated about being a judge?
what I liked about being a judge was just the challenge of getting in there and being able to look at every case like a problem that had to be solved. I really disliked the archaic language that was being forced on you, and I disliked the slowness of the processes. I tolerated the inefficiencies of individuals, especially in transcribing what I had done. So that answers that.
What is your favorite restaurant or cafe in Mumbai?
Restaurant in Mumbai?
Yeah. Mask. One new hobby that you picked up after retirement?
I've got so many old ones. Why would I bother to add to that?
Or one hobby that you revisited after?
Photography.
Okay, sir. Favorite dish that you love to cook?
That I love to cook?
Yes.
Salads. Any kind.
If not a career in law, what profession would you have chosen?
Probably writing, something to do with writing.
Okay, sir. One book that you can read over and over again.
Don Quixote.
One word that describes your court demeanor.
Aggressive.
Thank you, sir. That was indeed rapid. So, before we conclude this episode, do you have any advice for young lawyers and young law students out there?
Well, lots of advice.
Yes.
Don't give up hope. Keep bashing. You'll have wins and you'll have losses. Treat them both with equal disdain because they're both going to come to you one way or the other. Don't stop learning.
Right.
The day you stop learning is the day your career ends. And above all, remember that there is one asset that you have to build and then most jealously and zealously guard, and that is your reputation. It's your reputation for integrity, honesty, fairness, fair dealing with the opponent, with the court. You lose that reputation and nothing will compensate for it. No amount of money will compensate for it. You can have all the fancy cars in the world, but a lost reputation in a court of law is a total and utter disaster.
Right, sir. And I think this is something that we're not taught from the start, and something that you've come by after experiencing.
And that protecting that reputation can come at the cost of money, which is also something that I learned from Janak very early on. Do not compromise that reputation,
Right, sir.
no matter what you do.
So I think I hope that it was as interesting. I hope
Very
the episode was
interesting.
as interesting for you as it was for us.
And getting here was even more interesting.
This brings us to the end of our episode. This is Jinay Jain from GLC Law and Lore signing off.